This morning's docket. Case number 106748, Robert Blake Dummler v. Kansas Department of Revenue.
May it please the court, if I could please reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. The issue before the court initially seemed to be relatively straightforward, but based upon an order that just came out from the court last week, also asking us to address the jurisdiction of the court under KSA 8-1020, it appears that there are really probably two issues before the court today. The first would be, from the appellant's perspective, a matter of simple common sense statutory interpretation, which has to do with the timing, or the alleged timing, that is required when an individual wants to exercise their right to speak with counsel after they have submitted to a breath or blood test under the Kansas Implied Consent Law. The district court, as the court is aware, initially ruled that for an individual to exercise that right, i.e. the right to speak with an attorney after completing a breath test, it must be done so chronologically after the actual breath test is complete. It's obviously appellant's argument that that makes absolutely no common sense whatsoever and is not required in the actual language of the statute itself. The language of the statute itself does specify that an individual has the right to speak with an attorney after testing is completed. It does not say, nor does it even infer, that the exercise of that right has to take place after the test is completed. Instead, what it says is the timing or the logistics associated with that would have to take place after the individual has completed the breath or the blood test. That makes perfect sense both under the statute and makes perfect common sense. An individual is not allowed to speak to an attorney before they would take a breath test or a blood test. That would be an onerous burden upon a law enforcement officer to allow an individual to speak with an attorney beforehand, and is not what is required by statute. What is required by statute is after that individual has completed the test, logistically that would make sense that that is then the time that they would be entitled to speak to an attorney. Nowhere in the language of the statute does it ever specify, or would it make any sense to infer, that an individual, in order to exercise their ability to speak with an attorney, could only do that if they said so after they were done with the breath test. And that's precisely what happened here. There's no dispute that Mr. Dummler, on at least 2, if not 3 different occasions, asked to speak to an attorney. The officer wasn't exactly sure one way or the other, but did not dispute the fact that Mr. Dummler probably did ask to speak to an attorney. The district court found as a factual matter that Mr. Dummler had asked to speak to an attorney both prior to being arrested and then also while being read his implied consent advisories, exactly when he's being told that he has a right to speak with an attorney after testing is completed. The gotcha clause, or how it was interpreted by the district court and then also by the Court of Appeals, said, well, even though the officer knew that Mr. Dummler wanted to speak to an attorney, even though Mr. Dummler went ahead and completed the breath test as requested by the law enforcement officer, simply because Mr. Dummler then did not again renew his right to speak with an attorney after breath testing was completed, that he suddenly then did not actually exercise that right. That is not what is required for by the statute, and that makes absolutely zero common sense. I would imagine if you polled 1,000 lawyers right now and asked them how they would have to exercise their right to speak to an attorney if they were arrested for a DUI, probably 995 of them would not have any idea that they had to exercise their right only after both the breath test or the blood test was completed, and it would not be sufficient while being read their implied consent advisories if they told the officer, hey, I want to speak to an attorney, that would not be sufficient if they went ahead and completed the breath test and then did not renew their request to speak to an attorney afterwards.
Let me move you in a different direction. Is this a statutory right?
This is a statutory right, yes.
No constitutional implication?
No, this would not be a constitutional right.
And how does that statutory right to consult after the test relate to the administrative proceedings? And the purpose in asking that is that, we've said, it doesn't matter if you violate the Fourth Amendment rights, if it's not one of the issues that can be taken up, and that's why we ask you to be prepared to address that. It seems like this is even one step removed from the constitutional rights that we've said are not on the table. Do you understand what I'm saying? This is just a statutory right, and I'm not certain that I see how that relates to the whole administrative proceeding.
This is, and what the court, I believe, is referencing is essentially a line of cases that started after Martin versus Kansas Department of Revenue, basically indicating that the exclusionary rule does not apply to your driver's license or administrative proceedings under the Kansas Implied Consent Law. This is different than Martin, and this is different than a constitutional law.
Well, it wasn't so much the exclusionary rule. My understanding is that there are certain, the statute says you can bring up these issues, and a lack of probable cause or lack of reasonable suspicion to stop is not one of those issues. And what I'm asking is, why is the violation of the statutory right to consult with an attorney after the blood alcohol or breath test an issue that fits within 1020?
Because
H.
that is, and again, that's kind of the line of cases that came out after Martin. Martin dealt with the exclusionary rule, and nothing about reasonable suspicion to initiate a stop, which is what the issue was in Martin, is referenced at all in the Kansas Implied Consent Law. Now, probable cause, i.e. reasonable grounds, is referenced, and that is an issue to be raised. So the real issue, or the crux there, was, well, what about reasonable suspicion to stop? Is that really part of probable cause or reasonable grounds? And if it's not, should we apply the exclusionary rule even if that individual's rights were violated to the suspension of their driving privileges? This is different. This is a case where the legislature has specifically included this right, the right to consult with an attorney and the right to independent testing. They've always been coupled together because of the way that the language of the statute since its inception. So that right has been specifically enumerated in the Kansas Implied Consent Law. So this isn't like the reasonable suspicion issue where there was no reference to reasonable suspicion. There was no reference to even to constitutional rights in the language of the Kansas Implied Consent Law itself. This is a case where the legislature specifically created this right, not only created it, but required it to be for the licensee or the person under arrest to be informed of these rights prior to submitting to a breath or blood test. So they're made aware of the fact that they have these rights. And this has always been an issue, all the way 25 years. It's always been interpreted as an issue that goes to, that any licensee can raise, that if their right to either counsel or their right to independent testing was violated, that it would then prevent the state from then suspending their driver's license, because it is a right enumerated in the Kansas Implied Consent Law.
But as Judge Atchison pointed out, the right to a secondary test is specifically mentioned and a remedy provided. But it seems to me there's a difference between providing the notices and granting the rights contained in the notices.
Why would the legislature specifically specify and put the language in the statute that an individual has a right?
Anything. I'm just saying that if you go by the language of the statute, it requires the officer to give the advisories.
It also specifies that an individual has a right to consult with an attorney after testing is completed. That's clear. Has a right.
That's in the same subsection that says you have the right to consult with an attorney and may request an additional test. That's all together. And as Judge Atchison pointed out, the legislature then said, if you don't get the additional test, then that throws out the first one. But they didn't include
and why the legislature wasn't redundant with the right to counsel, I don't know, but this has been interpreted as a coupling of those rights ever since Ostermeyer back in 1990, and always has been interpreted as an actual enumerated, legislatively granted right under the statute. So that's why this is different than Martin and a constitutional right that this court or any other court would have to infer into or imply into the Kansas Implied Consent Law. This was specifically put in there. And the legislature's known, this court and the Kansas appellate courts have interpreted this as an actual right for the last 25 years. I don't know how many times they've amended the Kansas Implied Consent Law since then, but it's pretty close to 25 times. And during the entirety of that time, they've never taken issue with the fact that the Kansas appellate courts have always interpreted that the legislature intended to give those as rights, the right to consult with an attorney after completion of testing and the right for additional testing. If they did not intend those to be rights, then they shouldn't have put them in there, or they could have easily amended any of the statutes in order to make it clear, well, no, they're rights, but we don't really want you guys to put a remedy here.
Help
We've
me
always
with,
had, sorry, go ahead.
sorry. Help me with the statutory language in 1020H where it lists the things that are within the scope of the hearing, or rather it says the scope of the hearing will be limited to these things. Which subsection do we use? The one that seems closest, if I may, is C. A law enforcement officer has presented the person with the oral and written notice required. Do you have another section? And if you don't, how do we interpret present?
I don't have another section. It's been the appellate court's interpretation from the outset that an individual has a right to independent testing and a right to consult with an attorney. It's always been an issue allowed to be raised because it was clear the legislature intended to give a licensee those rights. Why give an individual those rights and then not allow them a remedy or not allow them to raise it if those rights are violated? If the legislature had not wanted that to take place, since the court has always interpreted those as rights that if violated would then prevent the KDR from suspending their driver's license. If that was the case, then during the last 25 years, they could have made it clear that they didn't want a remedy if those rights were violated. Those rights, because they are enumerated in statute, it's our argument, are certainly issues that can be raised during an administrative hearing, even if not specified, because of the fact the legislature took the time to enumerate them as rights within the Kansas implied consent law itself. It is not the same as a constitutional issue that is not addressed or raised anywhere specifically in the Kansas implied consent law. And I see I'm out of time, so unless there are any additional questions, I'll wait for my rebuttal.
Any more questions of council? Thank you.
Thank you.
May it please the court, John Schultz on behalf of the Kansas Department of Revenue. I was very pleased to see the courts issuing the order requesting us to address the issue as to whether or not the court had jurisdiction. I think it's very clear that the court does not have jurisdiction over this issue.
But you didn't raise the issue.
That's correct.
If it was so clear, why didn't you raise the issue?
Your Honor, with all due respect, I didn't do the briefing.
Counsel, if you'd
I'm sorry.
let the justices complete their questions,
I apologize. I thought he was finished.
it's a lot easier for us to understand.
I think you've answered the question. You didn't raise it below and you didn't raise it in your brief.
That's correct. It's my belief that the court always has a duty to look to whether or not it has jurisdiction on its own motion. The Court of Appeals didn't look at this issue. Mr. Holland did, in fact, address it very briefly in his brief, that we would probably be making that argument. And yes, we should have made that argument. Again, I didn't do the brief, so and I apologize for that. In the future, that will change, and I will do my own brief. So I will be solely accountable to this court. At any rate, 81020H2 allowed several issues to go on until this court decided in the Martin case in 2008 that it was an exclusive list and that it was exclusive of all of the other issues that were contained within that statute unless it was an issue on a constitutional basis or unless it was one of those issues enumerated, or there are a couple of others. The service of the DC-27 was another issue that can be raised. The statute, in fact, was enacted in 2001, and 81004, which enumerated this right to counsel and the right to independent testing, was enacted originally in 1955, and then it was modified again in 1985. So the legislature clearly knew of the existence of this right that they granted in 81004, but they clearly chose not to add that as a right within 81020H2.
How is that so clear?
Well, because
why does not
if they're going to, and I'm sorry.
Why does not the use of the term that they've presented those rights to the individual mean you've given them the right to exercise them, not that you've just handed them a piece of paper with them listed?
Well, because the court didn't come back and say that if there's an issue with regard to that particularly if you ask for independent testing, arguably that would not even be something you could raise in the context of the driver's license suspension appeal because the legislature did not enumerate that as one of the issues.
Counsel, if I could direct you to subsection G of H2, which says one of the issues to be decided is whether or not the driver failed the test, right?
Correct.
And so why wouldn't this issue, very issue that you're talking about, whether or not the driver was afforded the opportunity for a secondary test. Why isn't that just evidence that is relevant to determining that issue that's set forth in H2G? In other words, we know that 8-1004 says that the test is inadmissible if the right to secondary testing was denied. If the test is inadmissible, how can the state prove under H2G that the driver failed the test?
That's not the issue that was raised in this case, Your Honor.
Well, I understand that,
The
but
only issue
if we're talking about jurisdiction, however,
Okay,
why isn't H2G an issue that it is an issue that can be heard at the hearing, whether or not the driver failed the test? And wouldn't all the evidence that would be relevant to that determination also be able to be heard?
yes, because I don't think that 8-1004 necessarily requires suspension or suppression of the test result in the civil driver's license suspension scheme. I think that is more directed towards the criminal case. And again, I go back to the plain language of the statute. If the court had wanted to provide a remedy for failure to provide an attorney or failure to provide an independent testing, they could have put that in 8-1020, but they didn't do so. And then you go on further in the statute under subsection P of 8-1020, it says, such review shall be in accordance with this section and the Kansas Judicial Review Act, to the extent that this section and any other provision of law conflicts, this section shall prevail.
So,
This clearly defines those issues.
and if I understand your argument is that at the hearing, you can't present evidence as to the admissibility of the test, and that subsequent judicial review has no jurisdiction to review evidence with respect to the admissibility of the test.
I'm not sure I follow you. Are you talking about at the administrative hearing level, at the district court level?
Well, we're
I'm
looking
not
at the
sure.
we're looking at the jurisdictional statute that
Okay.
sets forth an exclusive list of issues that can be heard.
Correct,
And one of the issues is whether or not the driver failed the test.
correct.
And so your argument is that the issue is just whether or not the driver failed the test. You cannot look beyond that. You can't look to questions of whether or not that test is even admissible.
Well, certainly, if there's some challenge to the admission
Well,
of the
there
test
is
result.
in this case, isn't there?
No, there's not.
Well,
Because this all occurred after the test, and the right only attached after the plaintiff failed the test. And that's why it makes logical sense to make them reiterate their request after they've completed the test, because they don't have the right to begin with to consult with an attorney. They only have the right after they've submitted to and completed the test. So it makes sense that they would then have to reassert that right, not just to an attorney, but to independent testing. And the legislature clearly parsed those out, as Justice Johnson pointed out, and said the legislature gave you a remedy for failure to allow them to have an independent test.
But what's the purpose of the independent test? It's to rebut the bona fides of the initial test, isn't it?
One would assume that it is.
And if you carry that through, Justice Stiegel's asking, why can't the driver challenge the bona fides, and why isn't the right to consult with an attorney afterwards about getting second testing or what's necessary? Why isn't that all part of the issue that's before the hearing examiner? That's the question for you.
Because the legislature clearly treated those two issues differently. The legislature said in 8-1020 H2, these are the only issues you're going to have to deal with at the driver's license administrative hearing section or process. But the rest of those,
What does 81002F mean? When it says, if the requirements of subsection A are not met, the division shall dismiss the administrative proceeding and return any license surrendered by the person. So the legislature
this is
did.
8-1020. Is that what you're talking? I'm sorry, I'm not following the statute.
81002F. It says if they don't comply with the subsection A, the remedy is dismissal. So the legislature did provide a remedy.
They empowered the hearing officer with the power to dismiss a case if in fact the DC-27 was defective in some manner, or if there's a basis for them to set aside the suspension.
It says shall dismiss.
Okay? Again, I mean, if they presented this testimony at the time, and the hearing officer believed their
okay,
testimony, the hearing officer had that power.
So subsection A includes giving the advisories, does it not?
Correct.
So you're saying that, well, this says if you don't give the advisories, then the division shall dismiss. Would you agree with that?
Correct.
Okay, but you're saying that you can give the advisories and then ignore them and not comply with the advisories, and there's no remedy.
I think potentially that if that question were to come up, but in this case, the officer did comply with the statute because the plaintiff never requested that he be given an opportunity to speak with an attorney after he'd completed the test.
Let me ask you a question
And
on that subject, counsel.
Okay.
And now we're moving to the merits of the case as opposed to the jurisdictional argument. I understand it's the Department of Revenue's position that there's a bright line rule and that if the driver doesn't invoke the statutory right after the test, then, in other words, the driver has to invoke it after the test.
Correct.
What about the hypothetical, and I understand this isn't our case here today, but what if a driver before the test simply says, you know, maybe I'm a law student or maybe I'm a frequent flyer here and I know my rights, even before you read them to me, and I know I have a right to consult with an attorney as soon as this test is done, and I want you, the officer, to know that I want to do that. What happens then? I mean, according to the test that you're advocating, that very crystal clear invocation of the statutory right is null and void just because it happened a few seconds before the test.
It leaves the officer in a very interesting position because, first of all, suppose he submits to a blood test. Okay, the officer's not going to get that blood test until some time later, maybe months later, from the KBI. Does he then have to go back and talk to this person and say, oh, now that you've failed this test,
Well,
now you have a right to an attorney, and do you want to call your attorney?
you're not
that
answering.
doesn't make any sense.
Counsel, you're not. That's not an answer to the question I'm asking. I'm asking right there at the time, the driver clearly invokes his statutory right.
Okay.
However, he does it before the test is given. On what grounds can the Department of Revenue argue that placed no affirmative duty on the officers whatsoever to afford the driver the opportunity to talk to counsel?
Because, again, the right does not attach until the person has failed the test. And the officer gives him that information, but the officer doesn't know at the time that he's going to complete or submit to the test and complete it.
The statute doesn't say that, Counselor. 1001 K10, quote, after the completion of testing, the person has the right to consult with an attorney and may secure additional testing, end quote. So the right accrues after completion of the testing, not the failure. And it says a person has the right to consult with an attorney and may request or may secure additional testing. So it shall have the right. It doesn't say shall have the right to ask for. So the right is there.
But it does not attach until after, based on the plain language of that statement, after the completion of testing. So, should the officer then have to wait until the person, or should the officer immediately, when the person says, I want to speak to an attorney, stop everything he's doing and say, oh, well, let's get you an attorney right here, right now? That really throws a kink in the whole process because the officer has to read the implied consent advisories, has to wait a 20-minute deprivation period. If the 20-minute deprivation period expires, he has to start all over again and do the whole process again. Again, it's complicated too when you throw in the possibility of a blood test or a urine test that the officer won't get those back. So because the right does not attach.
Counselor, I don't understand what you're saying. Are you saying that the test isn't completed until you get the results? Is that what you're trying to say?
Correct. That's correct. If they refuse to submit to testing, do they have a right to counsel? That's not what that advisory says. They don't have a right before they submit to the test. They're told that in advisory number 3, that you do not have a constitutional right to speak to an attorney before submitting to the test. You don't have that right at the level of the PBT and their advice. You do not have a right to consult with an attorney as to whether or not to submit to this test or not. So the right only comes into play after they have completed testing. So it makes perfect, absolute, logical sense that they have to reassert that right after that.
Counsel, let's take an analogous situation. I think we'd all agree that the Miranda rights do not attach until we have a custodial situation. But if an officer would walk up to start a Terry stop and I would say, I'm not going to talk to you, I want to exercise my Fourth Amendment rights, those rights don't attach because I'm not in custody?
I'm sorry, as far as Miranda,
Well, I mean, isn't that a similar thing? Can't I preemptively exercise my right?
I think under Miranda, yes, you can.
Why doesn't the same apply here? Why can't I preemptively exercise a right that
Because
may not
this-
attach until later, but I can make it clear my intent before it attaches?
Because you don't have that right at that time. With Miranda, you always have the right to invoke your right to remain silent and not speak to the officer. In the implied consent arena, it's different. You are instructed at the PBT level. You do not have a right to consult with an attorney. Again, you are advised in the implied consent advisories. You do not have a right to consult with an attorney as to whether or not you should or should not take this test. So because you don't have that right all the way through, as if you did in Miranda, that right does not attach until after you've completed the testing requested by the officer.
So regardless of how many times the person who's been stopped says, I want to consult with an attorney, regardless of how many times that is asked, it's your position that is all a waste of breath until after the testing is completed. Is that
That's
correct?
what the case-
Is that correct?
That's what the cases have held consistently, with the exception of Lynch and one other earlier case. I can't remember that case right off the top of my head. But Lynch is the only case that's come back and said, it doesn't make any difference when you ask for an attorney. Then we're gonna provide one at some point, and you don't have to assert that right after it attaches, after you've completed the testing. So that's what the case law has been for many years. And again, until this unpublished Lynch case, that hadn't changed, I believe, in the last 8 or 10 years. I believe this court made the same finding in an early case, it was 2001 case, the Drake case. I believe this court made the same finding. So,
Right. Council's out of time. Do we have any further questions?
I do.
Yes.
Let me clarify what actually happened in this case. Mr. Dubner was first advised that he had no constitutional right to consult with an attorney with regard to whether to submit to testing. Correct?
correct,
And then he was advised that after the test, after completion of the test, he has the right to consult with an attorney.
correct,
And then he was advised of his Miranda rights that says he has the right to an attorney, and if he can't afford one will be provided for him.
correct.
And you're saying, and he's alleged to have been intoxicated at the time, and you're saying that he should have known that he had to delay asking for that attorney until after the breath test was done.
That's correct, because he's also advised at the time he took the PBT that he didn't have a right to consult with an attorney. He's also told that he didn't have a right to consult with an attorney to decide whether or not he should submit to the test.
But then he was told he has a right to an attorney and one would be provided for him.
And at the time that he invoked his Miranda rights, the officer stopped questioning as he was required to do under the law.
Any further questions? Thank you, Council.
Thank you, Your Honor.
This is not meant to be flipped, so please don't take it that way. This case really shouldn't be that hard. It's clear that the legislature intended for an individual to have the right to speak with an attorney after they get done taking a breath test. It's clear that the legislature intended for an individual to have a right for independent testing, and that's part of the reason they need to speak with an attorney after they get done with a breath or a blood test. It's clear that the legislature, in making that right very clear and enumerating that right, dealt with the timing of that right, not the timing of the exercise, the timing of when they are entitled to speak with an attorney. They're told you can't speak with an attorney before you take the breath test, but as soon as you get done, we'll let you talk with one, because you might want to take a blood test too, or you might want to take something else. That's pretty clear.
Functionally, how's that supposed to work? Let's just say Mr. Demler did have a right to, had the right that he effectively asserted his right to consult with counsel. It's 2 a.m. What's supposed to happen at that point?
You know, and
After the breath test,
this,
okay, I want to talk to counsel. Okay, talk to counsel. What's supposed to happen?
this isn't admissible evidence, but I've been doing this for a long time and argued many DUI cases in front of this court and other appellate courts. This is never an issue because district courts, for the most part, exercise common sense. And what happens is if an individual says, I want an attorney, they're allowed to try to call an attorney. Most of the time that doesn't work, but I'll be honest with you, I get lots of calls in the middle of the night, so sometimes it works and sometimes it doesn't as far as my clients are concerned.
And so how does the consultation then affect the validity of the initial test?
All the officer has to do is if it's clear, like it is here, the person wants to speak with an attorney, they take the breath test, they've got their breath test, they're done. The officer says, here's your phone, but call your attorney now if you want to. That's what you said you wanted to do earlier. Or if they say, I want a blood test, and they have to try to facilitate that without interfering with the individual's right. It's really not that complicated, and it's been going on this way forever.
And I think the question is, the practical application is that the consultation with the attorney can facilitate the obtaining the additional testing. Is that what you're...
Well, that was initially argued in the beginning that both the right to counsel and the right to independent testing had to be joined. That was kind of the Ostermeyer case and the Kelly case, which said, or argued, actually my father's case, argued that, you know, an individual only has a right to speak with an attorney about getting additional testing. And this court said, no, they're actually independent rights. They may be, the language may be together, the timing may be together as far as when you get to do it, but the exercise has never been, this court, nor any other appellate courts, said you have to exercise that right only after you're done with the breath test or the blood test. That just wouldn't make any sense. Just the same as it wouldn't make any sense for the legislature to say you have a right to speak with an attorney. You have a right. You can't be any clearer. The legislature is creating a right at that time. Oh, but by the way, if you don't do it after you get done with the breath test, and even if the officer doesn't let you speak with an attorney, there's no remedy for that right, that doesn't make any sense. And that's why I'm saying this case really shouldn't be that hard. The legislature was clear. You have a right to speak with an attorney. It doesn't talk about when you have to exercise that right. It talks about when you can, not when you exercise.
If we end up agreeing with your argument that there is no bright line prohibition on when the driver asks to see an attorney, what's your best argument from the record here that your client actually invoked his statutory right to an attorney prior to the test rather than invoking his Miranda rights? Because as I understand it, he basically said, I don't want to talk to you, meaning you, the law enforcement officer, any further until I have an attorney with me, which would seem to indicate, if I sort of put myself in the law enforcement officer's shoes, that he's invoking his rights under Miranda, as opposed to his statutory right to talk to an attorney after the test. Do you understand? Does that question make sense?
I completely understand. That's actually what Lynch dealt with, and that was actually my case, the Lynch case, where that was exactly what the state argued. He was only invoking his Miranda rights, he wasn't invoking his Kansas implied consent law statutory rights to counsel, so there wasn't a need to get him an attorney right then, they just had to stop questioning. And what the court, again, applying common sense, said, well, he's an officer, he's trained, if once he mentions the right to counsel, and he's been informed he has a right to counsel under the implied consent law, all you have to do is either allow him that right and say, here's a phone, call your attorney if you want to, or ask a follow-up question. Do you want to talk to your attorney right now, or do you just not want to answer any more questions until an attorney's present?
So your position would be that as soon as the desire to speak to an attorney is invoked, then there is an affirmative duty on the part of the state to make follow-up inquiries, essentially.
Yeah, and this is not an onerous duty. I mean, it is either here's a phone, or are you sure you want to talk to an attorney, or you just not want to talk to me anymore until an attorney's present. This is not complicated. And that's, again, get back to my point, is this shouldn't be this complicated. The legislature specified a right. It's pretty easy for an individual to exercise that, even if they don't understand the law, and it's very easy for the officer to comply with that right afterwards. Why enumerate this right and then say there's no remedy for it, and you have to exercise it only under these specific circumstances? It just doesn't make sense.
Do we have any more questions? Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. Clerk will take this matter under advisement. We now turn to the second case on this morning's docket. Case number 106807, State of Kansas v. Reed.
May it please the court, Richard Ney appearing for the appellant in this case, Samuel Reed. Mr. Chief Justice, I would request 3 minutes of time for rebuttal.
3 minutes is granted.
Thank you. Samuel Reed was tried for attempted first-degree murder, and part of the proceedings that led to his convictions were closed by the court, closed to the public. The courtroom doors were locked. And that was done without any Waller findings at all at that point in time. There were some post hoc findings at the motion for new trial, and it was done without clearly the consultation or consent of Mr. Reed, the defendant. We'd submit that the Court of Appeals, in deciding this case, used an erroneous standard. Clearly an erroneous standard when this court ruled in State v. Cox, 4 months after the Court of Appeals opinion here, that one, there can be no harmless error analysis in a closed courtroom situation. And the Court of Appeals applied a harmless error analysis in its discussion of this case. And secondly, that the court this court said it is inappropriate for a judge to do this kind of post hoc, after the fact, Waller determination. So clearly, the closure of the courtroom here was error, structural error. The defendant did not have to prove prejudice, and one can wonder how prejudice can be proved in that situation. And that's what this court said under Cox. And that Judge Burgess, at the motion for new trial / post-conviction motion, could not make the Waller findings in retrospect.
Mr. Name,
Yes.
all of that argument depends upon seeing this as a closure rather than like a sidebar or a consideration of a legal argument in chambers. That sort of situation. I mean, there are situations that occur after trial begins where it doesn't have to be public or it doesn't have to be in the presence of everyone in the courtroom. So how do we draw that line?
Well,
and why wouldn't we not draw it here?
Right. This case, I think it's easy to draw. We're not talking about maybe a discussion about a jury instruction that was done in chambers. What happened here was the critical witness in the case, Amos Becknell, the only person to identify my client as the shooter, was questioned about his willingness to testify. That, I would submit, was the most critical thing that happened in the courtroom in this case. That whole determination that he was unavailable and that he wouldn't testify, as I want to talk about in a second issue. But that was the most critical thing. This was not something mundane. It was not something offhand. It was critical, and it was done in the courtroom with Mr. Becknell administered the oath on the witness stand, but the courtroom doors locked.
That critical result versus critical stage, there's a distinction. There's a lot of things that happen at the bench where you get hammered on an evidentiary ruling that you've lost your case, basically. So I think that's no answer to just say that it was critical to the defense. The question is, why was it a critical stage of the proceedings as we understand that to be?
Thank you, Your Honor. Well, let me put it this way. Would the court have been fine, Justice Johnson, would you have been okay if my client had been excluded from the conversation, or not the conversation, the attempted testimony of Mr. Becknell? I would suggest no. If this is not something we would say, oh, it's just sort of pro forma, something at the sidebar, we could exclude the client. How can we exclude the public? I think that's the same line that we need to be drawn here. And I think it was absolutely critical from the standpoint that this set the tone for the rest of the trial, that he was going to be allowed to walk out of the courtroom and not testify, and his preliminary hearing testimony used.
Can I clarify?
Sir.
You're saying that if the situation would not permit the exclusion of the defendant, then it doesn't permit the exclusion of the public.
Yes, I think that's a way to draw this line.
So all the jury trials where we go into chambers and bring people in to give their excuses, that was actually a violation of public trial?
Well, I think there's certainly an argument to this, and this court has talked about addressing jurors even. Jury questions have to be in public in front of the defendant now. But let's look at another way. Let's compare this to Dixon. Okay? Why was Dixon, or what stage was Dixon closed? To read the verdict. I've got to tell you, as a trial attorney, there's nothing less critical in the sense everything has been done. That is just a ministerial act. We're going to read the verdict in open court. Jury's decided. The case is over. We just don't know what the result is yet. Only the 12 people on the jury did. But in Dixon, it was said, hold on, no. You cannot close the courtroom at that time. And if we're going to say Dixon is on the other side of the line, Justice Breyer, how could this not be on the other side of that line? And what's interesting, too, is that when Becknell testified at the preliminary hearing, which was later used as his trial testimony, that was an open courtroom. There was no need seen to close the courtroom at that time.
I have one other
Yes.
question, and this is just a fact question. It seems like there's some dispute with the Court of Appeals characterization of how the closure came to be. As I recall, the Court of Appeals opinion says that it was suggested by defense counsel.
Yes.
I know that you're taking issue with lots of the behavior of defense counsel, but it sounded like you disagreed with that characterization in your reply brief.
Yeah, very much so, Your Honor. And here's the transcript of that. The prosecutor actually, Mr. Phelps, the prosecutor says, look, he's not even willing to come in here. We need to get rid of the spectators. He says, take the witness stand even to state his refusal to testify. Phelps says, the prosecutor, if necessary, I want to know if the court or Mr. Pittman is willing to go to the library, the law library where Mr. Becknell is, in order to get that on the record. The court then says, well, I have no preference. I mean, obviously I'm able to do that. Mr. Pittman obviously represents the defendant in this case, and it's the defendant's rights that have to be addressed and afforded him. So, Mr. Pittman, what say you on that particular issue? Again, the question is not being put to him, do you object? It's, what about going into the library? And Mr. Pittman says it might be easier if we just emptied the courtroom than did it here. So, Your Honor, it's sort of like if you ask me, do you want fried eggs or poached eggs? And then say, I said I wanted eggs. Mr. Pittman is giving a choice of the library or the courtroom. That's the only question that's being posed there, and that's the only thing he is asked by the court about closing this courtroom. So I suggest that is not an invitation. It is just a response to the court saying, well, Mr. Phelps is saying the library, what say you? So I don't characterize it that way. And again, of course, we're raising an ineffectiveness claim based on that as well. But under City of Wichita versus Bannon, I think it's clear that this is something counsel cannot waive for his client. He can't waive a jury trial. Can he waive a public trial? There is nothing in the record, not a word in the record of Mr. Reed ever being consulted by the court about this. Is it okay with you, Mr. Reed? And Mr. Pittman's testified he never consulted him.
In what amounted to the ineffective assistance of counsel hearing, whether it's motion for new trial or 1507, we can argue about, but that he testified he didn't talk to him about it. But the law isn't crystal clear on the necessity of that, is it?
Well, we would say the Bannon case says counsel cannot waive fundamental rights. yes, I might be able to decide what questions to ask the witness, but it's not my choice whether my client has a jury trial or a bench trial. It's my client's right. I'd say there's nothing more fundamental, or at least on equal standard as a jury trial right, is the public right to a public trial. We're saying that's something an attorney can waive for his client? I suggest that's not true. And then we have, of course, Mr. Pittman making no objection, but also not agreeing necessarily to the using of this testimony once Mr. Becknell supposedly says he won't testify. And that's really our second issue that we'd want to talk about today. That was an error by the court, that my client was deprived of his right of confrontation. Because Mr. Becknell was never told by this court, and Judge Burgess admits in his ruling, he says, I acknowledge the words that were spoken at that proceeding, that there was no contempt sanction ordered. I would arguably acknowledge that there was no specific direct order for him to testify. Judge Burgess is saying that. What happens on the witness stand says, what if I were to order you to testify? Becknell says, well, I don't think I should have to. He says, okay, goodbye. Then defense counsel is asked, what's your position? He says, I'm not prepared to answer that at this point. And the court never comes back to it. And Mr. Pittman never makes an objection. Again, this was critical. This was the critical testimony of the case that came in from the preliminary hearing. And if you look at the preliminary hearing transcript, which you have as part of the trial, because it was read, Mr. Pittman asked about 10 questions. It's about 2 pages of transcript, 2.5 pages of transcript. He admits at the post-conviction hearing, motion for new trial, Mr. Pittman admits, I didn't even have the reports. I didn't even have Mr. Becknell's statement to cross-examine him. So he was woefully unprepared to do that. And we went in at that time all the things he might have cross-examined him about. We would submit that Mr. Reed here was denied a fair trial, a constitutional trial, by the closure of this courtroom without any inquiry by this court, and by use of this testimony from the prelim, without his consent, without any true findings, any order, and we of course cite this court to the Jefferson case, order that he submit his testimony. And remember, when the judge of the preliminary hearing ordered him to do the same thing, look, you're going to go to jail if you don't testify, he testified. So one would think that would have been effective with Mr. Becknell. I will submit the remainder of our 5 issues to the court and reserve my time.
On that subject, I think you only had 3 issues in your petition for review. Is that right? Didn't you pare down your issues in your petition for review?
I believe we pared them down.
Okay, all right.
Yes,
You just
Your Honor.
mentioned 5, and so I wanted to be clear on that. Okay, thank you.
And I think there's the cumulative issue, but thank you, Your Honor.
Any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. It's a little bit different since both petitions have been granted. I'd like to address the portions of my petition first, if I may, unless the court has other plans for me, which is fine as well. Of course, my petition starts with the beginning, which is Holt and the statutory authority, and whether the district court even had jurisdiction to entertain Mr. Ney's late motion for a new trial, which alleged all of the ineffective assistance of counsel claims.
Why is it a jurisdictional problem rather than a procedural issue?
Well, I think under Holt, it becomes a jurisdictional issue because the district court didn't have the ability to reach the merits of the claim because it was out of time. If that's not what, I guess if that's not what Holt means and that's not what the statute means, then the only question I'm left with is what does it mean? If it doesn't mean that you can't do it, then what does it mean and why is it there? And why did this court interpret it the way it did in Holt? I mean, it's important, at least from my perspective, it's important to realize, of course, that it's not that the defendant isn't going to be able to make these claims. It's just when he'll be able to make these claims. And this is sometimes, at least in my experience, where things get a little bit frustrating and difficult to understand when we take things out of order. The legislature has provided us with an orderly events of how these issues can be addressed, and we chip away at the clear statutory provisions that speak to that order, and we find exceptions.
Let's revisit something you just said, and that was that he's obviously going to be able to address them at some point if he wants to. Had the notice of appeal already been filed, then the appropriate procedure, because it hadn't been filed.
Right,
at the time
I
of
thought it was a
submission.
question, I'm sorry.
Well, we're getting there.
Right.
I'm doing the setup. At the time this motion or supplemental motion for new trial was filed by Mr. Ney, the time for a motion for new trial had expired. Everybody acknowledges that. There hadn't been a notice of appeal filed yet, though, which is usually the first step in removing jurisdiction from the district court, right? And then it's actually the docketing that deprives the district court of jurisdiction, correct?
That's correct.
That kind of goes back to my original question about jurisdiction versus procedure. But had the notice of appeal already been filed, then Mr. Ney's alternatives at that point would be to attempt to raise ineffective assistance of counsel on the direct appeal, at which point he would have been told, we don't let you raise that for the first time on appeal, or to file a motion for a remand for a Van Cleve hearing, right?
And that's what the district court and I believe the Court of Appeals indicated, but I think that's that's the problem with the process.
I understand. There's a process problem. But now we've had a hearing on the merits of ineffective assistance of counsel, correct? We've had, in effect, what Judge Burgess called it, a Van Cleve hearing, right?
And we were successful. So at
Right.
some level, it may seem ridiculous that I'm making this argument.
Well, I'm
because
asking what you want as a result.
What I would
given
like
what's
is
happened.
I would like for the court, just as they did in Berry, where there's a judge-made rule like a Van Cleve hearing, and there's a statute that speaks otherwise, to follow the statute. The statute indicates that you don't. It tells you when you get a lesser included offense in Berry. And we had a judge-made rule on felony murder that the underlying felony had to be weak or inconclusive. The court digested all of that and went with the statute. Said, we've got a statute here.
So your position today is that we should do away with the Van Cleve procedure?
Absolutely.
Okay.
To the extent it interferes with the clear statutory authority. The statute indicates you have 14 days, unless it's on newly discovered evidence. And if it's not based on, it's a calendar issue and the content of the claim. The district court has two issues to look at. Look at my calendar, look at the content of the claim. It's outside of 14 days, and it doesn't deal with newly discovered evidence. And again, it's important. These issues will be resolved. They just won't be resolved right now. And that's the way that the legislature has set this up. And in Baker, as we indicate, you can't have a 1507 unless you're under sentence. And there's a few things that we know for sure. This defendant was not under sentence, and this motion was outside of 14 days.
Right. We know it's not a true 1507 because of the requirement to be under sentence. We know it's not a true motion for new trial, or at least not a timely motion for new trial. I'm not disagreeing with you on those points. I'm just saying they're procedural, and I'm not sure they're jurisdictional. That's the problem.
Well, where is the authority to bring the claim? That's the jurisdictional issue. It's not, I can bring any claim I want unless you show me something that says that I can't.
Well, up to this point, there have been authorized ineffective assistance of counsel attacks during that period of time. And in fact, what we've said repeatedly, and what I think the statute and the rules say, is you can't bring them for the first time on direct appeal. So this wasn't on direct appeal yet. This was still in the district court. Why is it not to everyone's advantage to go ahead and get it done?
I don't feel that it's not to everyone's advantage. The problem is that the statute doesn't provide for it. That's what jurisdiction is. I mean, sometimes it might be to everyone's advantage to disregard the statutory authority. Okay, but we've been told that we can't waive those. The parties, sometimes it's to the advantage to get things done now. But the problem is the statute doesn't allow for it. There's no jurisdiction. There are a number of cases where the court has indicated that the only problem is the parties can't waive jurisdiction. And I believe that's what this is. Otherwise, again, I'm left with the question that has concerned me and the state since the district court, because it's important to remember we lodged this objection at the district court level. What does the statute mean then? It certainly doesn't seem to just be advisory. And again, you will have your claims litigated, but in a timely manner. And you can forego your direct appeal if you feel as though ineffective assistance is the real issue in your case. You can forego your direct appeal, bring your ineffective assistance claim now. You don't have to wait. That's your decision. But unless there are any other questions on what I'll call the Holt issue, I'd like to go on to the sentencing issue. And I don't mean to indicate that it's clear in the sense that we, absolutely should be victorious, although I do feel that way. But it's clear to me when I read the record that the district court in this case seized on the sentence disparity issue. That was the issue. And it's my understanding that precedent from this court and the Court of Appeals indicates that you have a duty as a district court judge to articulate at sentencing what is the foundation for your departure. And we also have case law that indicates that catch-all phrases of taking everything into account, I find that that's not sufficient. We need to know what it is. Now, the Court of Appeals in this case never ruled on our issue. They never ruled whether the sentencing disparity issue is a substantial and compelling reason to depart. What they did is they told us that Mr. Ney filed a motion that contained more than that. I understand that. And they also indicated that at the sentencing hearing there was more discussion than the sentencing disparity issue. I get that as well. The problem is that the district court, when articulating the substantial and compelling reasons, seemed to have limited his reasonings to that sentencing disparity issue. And our argument is that is not a substantial and compelling reason. It has nothing to do with the defendant or the particular characteristics of the defendant. It has everything to do with what the legislature has set for the sentencing. And your dislike for that sentence should not equate to a substantial and compelling reason.
Didn't he mention a couple of times his age? And a couple of times I understand that he kind of melded it all together and kind of did the disparity deal, but didn't he also cite public safety and age?
And I think that
and so how do we look at that? I mean, it wasn't as crystal clear as you would like to see it, I suspect, but it's in there.
That must but I think that's where the cases indicate that, hey, we got to know. We have to know what your substantial and compelling reasons are. We are not going to go back and review the sentencing and say, oh, well, look over here on page 5, he talked about this, someone mentioned that. What are your substantial and compelling reasons? You have an affirmative duty to articulate it. And that's clearly where our position and Mr. Ney's position, the Court of Appeals position, they clash. How far are we going to go in and dig this up for you? Or are we going to do what you're required to do and what we've said you're supposed to do when you articulate those substantial and compelling reasons? Unless the court has any questions on those issues, I'd like, of course, to address the public trial issue. I think it was Justice Johnson that Mr. Ney had indicated, this decision, the content of this decision was something that was important in this case. I don't think that we can determine whether we need to open a hearing to the public based upon a future event and its importance to the case. That, to me, isn't the right answer. I think it was Justice Beyer that indicated that this was more akin to a sidebar. And I believe that to be true. There were no fact-finding process that was involved here.
Well, what was this proceeding? Was it a hearing on a Becknell contempt hearing? What occurred? I mean, it's kind of it's not so distinct from the trial, and yet it is part of it's something distinct to Becknell and trying to understand what his reasons are and make a legal determination on his unavailability. So I think characterize in your mind or in your words what this was.
I think that's what it was. It was a legal determination of whether this person was going to be found unavailable or not. And to a certain extent, it may have been done to protect the defendant, in that I know that it's with respect to the jury, but there are cases that indicate it is error to put someone on the stand that is going to invoke their Fifth Amendment right. I know that's not what we're talking about, but that's similar to what's happening here. I'm not going to confuse this trial, this jury process, with someone that we know from the preliminary hearing, and now I'm being told again, is going to possibly refuse. I'm not going to have this circus in front of the jury, and then the closure. I understand Mr. Ney read a portion of the transcript to you, but there's a reason that the state and the Court of Appeals independently have determined that the defense counsel requested this. And I think you need to also look a little bit further into defense counsel has told us this was his strategy with respect to this testimony. He was aware of how sympathetic this victim comes across. He knew what he was going to say, and he wanted this person removed from the jury's view, at least. And so, in order to protect the defendant, he doesn't care how this happens. I just don't want this testimony. And I know I'm jumbling the public trial and the finding of unavailability, but I think it's all together. It's all rolled up into one decision. I know the Court of Appeals ran through a number of contingencies. I believe that is, from my perspective, an appropriate way for the court to go through as well, because first we talk about waiver. And I don't know, Mr. Ney indicates that it's clear that you can't waive this right on behalf of your client. I don't think that's what the case law indicates. I don't think that it's clear at all. I think that the case law indicates that, in fact, you can. And it's more of an issue of the attorney having control over the conduct of the trial versus the guilt determination phases of the trial. I can't put it any better than what I saw in the Court of Appeals opinion when they cited to the Idaho Court of Appeals case of Overline. And if I may, a unifying characteristic of the rights requiring personal knowing waiver by a defendant appears to be that they are of central importance to the quality of the guilt determining process and the defendant's ability to participate in that process. On the other hand, the absence of the public in the particular case does not necessarily affect qualitatively the guilt determining process or the defendant's ability to participate in that process. I think that's a pretty good way to put the difference between the right to counsel, the right to a jury trial, the right to a public trial. And that's why, although case law indicates that this issue is subject to structural error, they look inside. Well, what actually happened here? Was this evidence, was the courtroom closed during the presentation of evidence, or was it something else? Was it a partial closure? Was it a total closure? We have the Waller questions, which indicate that chips away at a structural error. Why are we going, if a true structural error indicates the error happened and we're done? Waller doesn't do that. In fact, you don't need to look any further at Waller to realize that this is it's something less, because look at the remedy. Waller's important not only for what it said, but for what it did. It's a qualified right. Waller did not reverse the conviction. How important is that? Everyone wants to go, well, Waller says this, Waller says that, Waller says this, Waller says that. Waller's important for what it did. It sent it back for a new hearing on the suppression issue. It's a qualified right. It can be chipped away at under appropriate circumstances.
Any further presentation, counsel?
No, Your Honor, unless the court has any questions.
Any more questions? Thank you.
We respectfully request that the conviction be affirmed and the sentence be reversed. Thank you.
May it please the court. We first submit that the state has waived the argument on the Holt issue They've raised this as jurisdictional. That's what their brief says. They claim lack of jurisdiction. And unless this court is, at this point, willing to find that this is a jurisdictional issue, which is in clear contravention to Kirby and Kingsley, which have never talked about this as jurisdiction, then there is no issue here for the court because the state didn't raise it. As to, and again, as I told Mr. Loudon before we started here, well, what is it? Let's go back and I get a second chance to do this hearing. I mean, what is the point of that? Is this really, they're just asking for an advisory ruling of this court? That's what it sounds like to me here. But I would submit if this court says, yes, Mr. Loudon is right on this, then I get a do-over. Is that, perhaps I should be arguing his point. As to the sentencing issue, the Court of Appeals was very clear and listed in its opinion the 4 issues I raised on the downward departure motion. And said that the court, in making the ruling, talked about more than one of those issues, and said in its ruling, take into account the nature and circumstances of the crime, the history, character, doing the sentencing. The court says, yeah, principally I'm relying on something, but he talks about these other issues. Are we really going to have a standard that we measure how much time the judge spends talking about a particular issue as to whether that's the issue he's relying on or not relying on? And to go back on...
Whose burden is it to make certain the trial judge gets the appropriate findings? You know, we've said, yeah, we put that burden on the court to make the findings, but we also put the burden on counsel to complain if they think they're inadequate. And so in this case, would it be the defense burden to make certain that there's the articulation of sufficient factors to support the downward departure?
Well, I would suppose it's also the state's burden to say that as well. If they're challenging it, I would say this is their burden in this case. But finally, just concluding with the whole issue of the hold argument, you know, let's remember what happened here was my client was dissatisfied with his counsel. Then I entered my appearance, again, after the 14-day time period had lapsed, but well before sentencing or before sentencing. Are we really going to force a defendant to say, I can't raise these issues in a motion for new trial or in some way prior to appeal, even prior to sentencing, we're talking about, prior to sentencing, because I have an attorney who I'm saying is ineffective? I mean, that really is the catch-22, isn't it? We have an attorney, trial attorney, who we're saying is ineffective, but we're saying he has to raise, because it's pretty tough to get an attorney in 14 days, a new attorney, he has to raise his ineffectiveness for the motion to new trial. I think that's requiring more than a young defendant like this can do. And so I think that's why we have these kind of cases like Kirby and Kingsley, you know, not marrying us, binding us to that 14-day rule at times, and considering this as a post-conviction proceeding.
You did argue ineffective assistance on direct appeal, correct? I mean, you did bring the argument.
Right.
So, I mean, that kind of takes us back to what kind of remedy the state should have at this point. I mean, you attempt to raise it on direct appeal, then we respond either by saying you can't do that, or here's a Van Cleve hearing on the issue because it looks like there could be something there. Or we decided on the merits because we've got enough in front of us already.
Right. And Your Honor, I think if you look at this case uniquely, we're raising the closed courtroom. The companion issue is the attorney didn't prevent that from happening. This is where really the ineffectiveness claim and the substantive claim, if we call it that, are married. And the same with the issue of the confrontation claim and the ineffectiveness claim. These are really all of a part that really make sense as one appeal and not two.
How far are we being asked to extend this statute? Do we extend it just for IAC claims? or are you suggesting we go farther?
Well, certainly a new evidence claim, the statute even contemplates.
I understand that, but that's, what you're asking us to do is not in the language of the statute, as I understand it. So I'm asking you how many different types of claims would you think we should allow to be raised outside that 14 days besides ineffective assistance of counsel?
I think typically the Van Cleve hearing has been limited to ineffectiveness claims. Matters that could not be raised directly on appeal that relate to the constitutionality of the conviction. So I guess other than new evidence, I'd be hard pressed to come up with other kinds of claims other than ineffectiveness.
So what do we do about the plain language of the statute?
Well, again, if I had been in the case several weeks earlier, I could have asked for an extension of the time of the 14 days. I understand what the statute says, but again, we have the court being able, in many instances, to treat certain types of proceedings, even from pro se litigants. And in a sense, that's what Mr. Reed was until I entered the case, if he had ineffective assistance of counsel. We have many kind of situations where the court has treated certain claims as, oh, we're going to treat this as a 1507 or a 1501. So this is not unique, and there's a line of cases, as we've cited both in our reply and in our response to the state's motion to dismiss, of those cases. I think the statute can be looked at as not so restrictive as to have no breath for the court to say, we can consider it in these terms. I just don't think we can be, that the court should bind the proceedings in that way.
All right, thank you.
Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time the court is in recess for 15 minutes.